Hey, what's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. I am coming to you today with a topic that I was hoping we wouldn't see in Colorado, but we're starting to see it, and I'm starting to hear about it quite a bit. I'm getting the legal hotlines getting flooded with kind of frantic and concerned phone calls over the last, I would say, 3 to 5 weeks, roughly, from law firms, basically sending a letter, a demand letter, a response demand letter to allegations related to ADA and or fair housing website compliance. So we talked about ADA website compliance years ago, and Colorado, other states have had a lot more active people pursuing demands, settlements and such for brokerage firms' failure to comply with accommodation under the ADA, Americans with Disabilities Act, in terms of mostly screen readers and the ability of somebody who is not able to see visually. They have this screen reader technology, and certain websites have the ability, most websites should really have the ability to convert that text and essentially read the screen on a website to somebody who's not able to see. And obviously, providing accommodation to individuals who are blind is certainly super important. But we've seen in other parts of the country some demands and allegations by attorneys who have been looking to basically get settlements or potentially allege filing lawsuits against brokerage who haven't been providing that accommodation. And we hadn't seen much of that in Colorado until just recently. And so over the last 5 or 6 weeks, I've probably received, 15 to 20 different phone calls from realtors who have been sort of frantic and saying, hey, I got this demand letter. It is a legal demand letter. It's being sent by primarily, I think, one specific law firm here in the metro area, and essentially saying, hey, we have tested your website. Your website is not compliant with either Americans with Disabilities Act or fair housing and the requirements of providing accommodation. Because this individual who visited your website wasn't able to utilize their screen reader. And please contact our law firm regarding settlement for potentially attorney's fees and other damages, et cetera. Very official looking letter, and so created a lot of concern in our brokerage community. Primarily, I think it's smaller brokerage firms that are being targeted with this, but it is nonetheless being done very actively. So these demand letters are flying. So I want to mention a couple of things, and then I'm going to give you a fantastic resource that NAR just pushed out in the last couple of days via a link somewhere here. First of all, in terms of ADA website compliance and that a website is a place of public accommodation under the Americans with Disabilities Act, it was a Court of Appeals decision out of the 11th Circuit that was just issued within the last, month or so, that basically has described the fact that, or has settled on the fact that a website is in fact not a place of public accommodation. And so there's a lot of details to that, and I'm not going to break it down. That's a very favorable case in terms of being able to respond to this concept that somehow under the Americans with Disabilities Act, a brokerage firm is responsible for providing accommodation because it is a place of public accommodation. That was not agreed with by a federal court of appeals, a pretty significant federal court of appeals in terms of its analysis. So that was a very positive decision in terms of refuting some of this stuff. So I would say that as it relates to the ADA accommodation. And then fair housing, I think traditionally the expectation has been that fair housing has to do with the denial of housing services, but not necessarily the ability to communicate. And so I think this is the first I've seen under fair housing an allegation that a failure to provide accommodation through a website is somehow a violation of fair housing. And I don't think it's necessarily supported based on the traditional concepts of fair housing. So armed with those two things, NAR has provided a form letter, and we're going to make sure that it's linked. If you're viewing it on YouTube, then it'll be linked in the area below where you can download and utilize that. If you're on Facebook or viewing this in some other way, it's maybe linked above. Wherever it is, you will have with this video a letter, a form letter that NAR has provided to its members that I think is a fantastic resource that articulates what I've sort of just described to you here today. And I would encourage you guys, if you've received these demand letters, to go ahead and download that. You can sort of fill in the blanks. It's very easy to manipulate, and respond with this letter to let them know that you're in fact not going to be offering a settlement and are well aware of these recent developments in important legal developments in law. So if you've got one of these letters, I wouldn't lose a lot of sleep over it, but I would utilize this resource that's here, and armed with a little bit of instruction and information, as well as this response letter, hopefully you're able to respond eloquently to the claims and demands that are being made. And again, we're seeing them pretty aggressively hit Colorado right now. So hopefully this is timely and helpful. Again, NAR's resources are always fantastic. At CAR, we've got a pretty good resource ourselves. The legal hotline, which is available from 9 to 12 and 1 to 4 Monday through Friday. If you've ever got questions on this stuff or anything else, feel free to utilize that. Always love hearing from you there. Take care, guys. We will see you on the next edition of Legal Bites.